Good evening, one and all. Manaki today we are here to discuss about the act, that is Hindu Marriage Act 1955. Hindu Marriage Act 1955, Hindu Marriage Act 1955. What is the main intention behind the enactment of this act అనేది మనం ఫస్ట్ తెలుసుకోవాల్సిన పరిస్థితి ఎంతైనా అవసరం ఉంది. Why? Because to enact an act, there is a long discussion. There will be a long discussion by the enactors. That means ఈ యాక్ట్ ని ఎందుకు, వాట్ ఈస్ ద పర్పస్ ఆఫ్ enacting this act అనేది స్టేట్మెంట్, రీజన్స్ అండ్ ఆబ్జెక్టివ్స్ we have to go through first. This act is, as we discussed from the act, we can see that the we can see that as seen from this act itself, we can see that the act is of the year 1955. What is the situation prior to 1955 అనేది మనం ముందుగా తెలుసుకుందాం. So the situation prior to 1955 is there is polyandry and polygamy. అంటే polyandry, polygamy అంటే ఏంటంటే ఒక మగ వ్యక్తి ఎంతమందినైనా పెళ్లి చేసుకునేటువంటి పరిస్థితి ఉంది. అలాగే ఒక ఆడ వ్యక్తి కూడా ఇద్దరు ముగ్గురు అంతకు మించి వ్యక్తులను కూడా పెళ్లి చేసుకునేటువంటి పరిస్థితి ఉంది. బట్ దెర్ ఈస్ నో స్పెసిఫిక్ రెగ్యులర్ కోడ్ ఆర్ సంథింగ్ ఎల్స్ యాక్ట్ which regulates the marriage institution prior to this Hindu Marriage Act. So to streamline the process and to provide some sanctity to the marriages, this Hindu Marriage Act has been introduced by way of a bill into the parliament, and it has got the assent from the president on 18th May 1955. On the same day itself, this act has came into force. The act number is 25 of 1955. Act number is 25 of 1955. So why I'm stressing about this specifically means the persons who are interested to become judges, junior civil judges, for this numbers, I mean the number of the act as well as the date on which the act has came into force is very important. So please note this. The date of commencement of this act is 18th May 1955. On the same day itself, after receiving the assent from the president, this act has came into force on 18th May 1955. And this is the 25th act of the year 1955. Please note it down. Okay. So now coming to these sections, how many sections that are covered in this means there are nearly 25 to there are 28 sections. 28 sections is Hindi. 28 sections are there in the Hindu Marriage Act. So one by one we are going to discuss. First section is that short title and extent. What is meant by short title and extent means the nomenclature of the act, title of the act. What is the title of the act means we know that this act is called as Hindu Marriage Act. This act is called as Hindu Marriage Act. And what is meant by extent? Extent means to which area, from which area to which area this is applicable, and to what is the area of application. That means to which extent this code is going to apply. That will be discussed in section 1. So if we read from section 1, that is short title and extent. In the opening lines of the act itself, it is clear that this act may be called the Hindu Marriage Act 1955, and it extends to the whole of India except the state of Jammu and Kashmir, and applies also to the Hindus domiciled in the territories to which this act extends, who are outside the said territories. So while we are reading this section 1, subsection 1, it is clear, but there is no ambiguity. When it is coming to section 1, subsection 2, this act extends to whole of India except the state of Jammu and Kashmir, and applies also to the Hindus domiciled outside the territories of India. That means what is meant by let us have a discussion on section 1, subsection 2 now. So in this subsection 2, it is we can see that this act is applicable to whole India except to Jammu and Kashmir. Now, after dissolving this Article 377, this act is made applicable to all over India, including the Jammu and Kashmir. Now, coming to the second part in this subsection 2 of section 1, we can see that the territories to, it applies to the Hindus domiciled in the territories to which this act extends who are outside the said territories. So here we can read that the words, that is Hindus domiciled in the territories to which this act extends who are outside the India. That means what is meant by domicile? Domicile is nothing but the person's legal address of a person. Person's legal address, that is permanent legal address of a person, is nothing but domicile. That means, for example, if A and B are married in India, who are permanent residents of India, permanent legal residents of India, have got married in India, but they are residing currently at United Kingdom or somewhere else. So here we can see these persons have after the marriage, they have got some disputes in their marriage institution, marriage life, and they want to break the marriage. Now, in this case, what will happen means, both are Hindus, but they are residing at outside the country, but their permanent address is of India. Here, as per the general rules of international personal laws, so the law of domicile will be applied. That means the domicile here is A and B are domiciles of India, and their law is relating to the Hindu Marriage Act. So even the persons who are residing outside the territories of India, but they are who are domiciled in India, for them also the Hindu Marriage Act applies. So this should be understood clearly. If anybody is having doubts, you can ask me at the last. Please note it down if you are having doubts, please. Coming to section 2, which is application of the act. Application, wherein on plain reading of the section 2, we can understand that to whom this act is applicable. We can say this Hindu Marriage Act is a personal law. Personal law means this a law which is specifically the law which is specifically applies to the specific religion, like Hindu Marriage Act, Hindu Succession Act, Mohammedan law, Christian Marriage Act. So these are the laws which are meant for specifically some religion, that like which act we are discussing now. So this is the act which is specifically enacted for the Hindus. So we can call this act as a personal law. Moreover, in this section 2, application of the act. That means to whom this act is going to apply, that is discussed in this section 2. So from section 2, subsection 1, if we read that, this act applies to any person who is a Hindu by religion in any of its forms or developments, including a Veerashiva, a Lingayat, or a follower, or a Brahmo, Prardhana, or Arya Samaj. That means any person who is a Hindu by religion. So this act applies generally to all the Hindus by religion. Next, including Veerashivas, Lingayats, the followers of Brahmo, Prardhana, and Arya Samaj. So to this set of persons, this Hindu Marriage Act is applicable as per section 2, subsection 1A. Coming to subsection 1B, to any person who is a Buddhist, Jain, or Sikh by religion. To any person who is a Buddhist, Jain, or Sikh by religion. And coming to subsection 1C, to any person domiciled in the territories to which this act extends, to any person who is domiciled in the territories to which this act applies, who is not a Hindu, who is not a Muslim, uh, coming to this subsection 1C, to any other person domiciled in the territories to which this act applies, extends, who is not a Muslim, who is not a Christian, who is not a Parsi or Jew, Jews by religion. So unless and until he is proved that he is belonging to some other religion, he is presumed to be a Hindu. He presumed to be a Hindu as per the subsection 1C of section 2. So this act is applicable to entire India. I mean the entire persons who are domiciled in the India, and this act is applicable to the persons who are not Muslims, who are not Christians, who are not Parsis, who are not Jews, and to all the persons until the contrary is proved that he is not belonging to the Hindu, like that. So in this way we have to understand the subsection 1C. Now coming to the explanation that what explained in this section 2, that is, the following persons are Hindus, Buddhists, Jains, or Sikhs by religion, as the case may be. So now who are Hindus? Now we can see any child, legitimate or illegitimate, born to the Hindu parents. So when the case A, for example, if A and B are Hindus, if the child is born, so the child is a Hindu by birth. He become a Hindu by birth. In second case, if A is a Muslim and B is a Hindu, if the child is brought up and raised as per the Hindu religion, then he by the mother, that is B, so he will become a Hindu, or by conversion or reconversion. So by conversion, that means if a Muslim person wants to profess the Hinduism, he wants to follow Hinduism. If he accepts the Hindu, then he will become, if he converts by following rituals, he will become Hindu. If any person who has converted into a Muslim, from Hindu to Muslim, again he converted back to Hindu, then he will become a Hindu. So conversion and reconversion, the person who has converted from his religion to Hinduism, or who has reconverted, again converted, also becomes a Hindu. So these things are discussed in this subsection 1. And now coming to subsection 2 of section 2. This Hindu Marriage Act is not applicable to the scheduled tribes who are discussed under Article 366, subclass clause 25 of Indian Constitution. So if we read this Article 366 subclass, clause 25, there is a referral about Article 342 in the Indian Constitution. What is Article 342 in Indian Constitution means? So the government of that specific area, as per consultation with the president of country, so they are going to identify that a set of persons are belonging to scheduled tribes. So for scheduled tribes, there is no application of Hindu Marriage Act. They will be having special laws as per their locality, that means tribal areas. So they are not applied with these laws. So they will be having some separate laws. So if any government wants to apply this Hindu Marriage Act to that specific scheduled tribe areas or specific persons of specific set of tribe, so then the government first has to issue a notification in the public gazette, government gazette, that so and so act is applying to the separate set of the scheduled tribes. Then it will be applied. So without making a notification in the gazette, no, this act cannot be applied to the scheduled tribes, that we can say it. So now coming to this subsection 3 of section 2. The expression Hindu in any portion of this act shall be construed as if it is included a person who, though not a Hindu by religion, is nevertheless a person to whom this act applies by virtue of provisions of this section. This act says that this section, subsection 3 of section 2 says that though he is not a Hindu by religion, this act will be made applied to him unless it is proved that he is belonging to some other religion. So now coming to section 3 of the Hindu Marriage Act, which wherein we will see the different definition part, the definitions for different terms. That means now coming to the section 3, which is the definition part, in this act, unless the context otherwise requires, the expression custom and usage signifies. Here we can see that the custom, what is custom and usage? So a custom and usage signifies any rule. Custom and usage means any rule which has been constantly followed from the many years without any interruption of something else, without any disturbance. So from the olden days to present days, that the custom or usage has to be followed with a specific religion, I mean specific community or specific persons, set of persons, that should not be disturbed. Without any disturbance, it should be followed from then to till this day. So that thing is mentioned in this. And how a custom and usage should be means, a custom and usage shall not be opposite to, it should not be opposite to a public policy. It should be reasonable but not unreasonable, and it should be certain, specific ground. In this we can see that for example, for this section 3 subsection A, we can discuss an example. Like for in some areas we can see that like in some tribals we can see we have been hearing some atrocities against women in the tribal areas, like before marrying her husband, she has to I mean, we can literally say like dating. She has to date with her husband's father, which is highly unacceptable thing. So, but as per their customs and usages, that is the practice that has been followed by them. So such type of custom, which is opposite to public policy and which is unreasonable. So see, she is marrying a person she is marrying a person, but there is no need for her to have to be with her father-in-law before marrying her husband. So that kind of things are unreasonable. So this should not, that kind of customs or usages should not be, that cannot be treated as a custom and usage. That is the section 3 subsection A. So a custom and usages rule shall be certain. It should be certain, unreasonable. I mean, should not be unreasonable, and it should not oppose to the public policy. Coming to in definition part, subsection B of section 3, it is wherein it was mentioned as a district court. District court means a city civil court. I mean, a senior civil judge court. It may come I mean, this is a matter relating to civil matter. So that is the reason why the courts which will deal with these acts are relating only specifically relating to this civil matters, right? So city civil court will be the district court. So district court means a city civil court. It may come like the jurisdiction depends upon like area and the nature of the relief which we are asking. So if you are filing, if any party is filing a suit for a declaration, it can be filed before even before a junior civil court also. And coming to this, when we are filing the matrimonial issues, I mean matrimonial litigation to the persons who are residing in the rural areas. So rural areas are where the family court is not established. So ultimately, the jurisdiction vests with the senior civil judge court, and wherein the family court establishes, because family court will be established in the places where the population is more than 1 million. So in such cases, directly the family court will be having the jurisdiction, and it is the district court. Obviously, we all know that it is a district court. So the jurisdiction is conferred upon the family court to entertain these family matters. So in all those cases, for all the matters relating to this urban jurisdiction or metropolitan jurisdiction, the family courts will be having the command over all the courts, and the litigation has to be filed before the family court only, and junior civil judge courts, the other civil courts, jurisdiction will be ousted. Now coming to full blood, half blood, and this uterine blood. So uterine blood is discussed in 3 subsection D. Half blood, full blood is discussed in 3 subsection C. What is full blood? What is half blood? I will say an example. A is a husband, B is a wife. A is a husband, B is a wife. They have C and D are children. So their marriage is a legitimate marriage, and the children are C and D, who are full blood, because one father, one mother, and their children are C and D are full blood. Now coming to what is half blood. Half blood means A is a husband, B and C are wives. So it may be the marriage at the time, marriage was solemnized in presence of either persons. B marriage was done as in the presence of C, like another wife. So A is the husband, B and C are the wives. So A, B. For A and B, the children are 1 and 2. For C and D, for A and C, the children are 3 and 4. Here, 1 and 2 are full blood, 3 and 4 are full blood. For 1 and 2, 3 and 4 are half blood. So they are related by 2 mothers for 1 father. So in that case, we will term such relationships as a half blood. So it's not a full blood, it's half blood. These terms should be remembered because it is very important. These terms are used for even succession act also, in the succession act also. Now coming to uterine blood. Uterine blood means which is opposite. Hello?
Sir, once repeat. Half blood.
Sir.
Sir, half blood గురించి చెప్పరా?
Half blood. So please listen. Half blood గురించి చెప్తా చూడండి. A okay. A B okay. C. ప్లీజ్ మెన్షన్ ఇట్ అండి. ప్లీజ్ నోట్ ఇట్ డౌన్. మీకు పేపర్ ఉంటే పేపర్ రాసుకోండి, చెప్తాను. ఏ బి సి. సో ఏ ఈజ్ ద హస్బెండ్, బి అండ్ సి ఆర్ ది వైఫ్స్, భార్యలు. ఏ వచ్చి భర్త, బి అండ్ సి వచ్చి భార్యలు. ఏ నుంచి బి ఒకే భార్య ద్వారా కలిగినటువంటి సంతానం ఉంటే ఫుల్ బ్లడ్ అండి. ఇద్దరు భార్యల ద్వారా కలిగిన సంతానం ఏమవుతారంటే హాఫ్ బ్లడ్ అవుతారండి. సో ఇప్పుడు ఏంటంటే ఏకి బి అండ్ సి ఆర్ ది వైఫ్స్. సో వాళ్ళకి ఇద్దరిద్దరు పిల్లలు 1 and 2, 3 and 4. సో 1 and 2, 3 and 4 వీళ్ళంతా ఏమవుతారంటే దే ఆర్ రిలేటెడ్ బై హాఫ్ బ్లడ్, నాట్ బై ఫుల్ బ్లడ్. సార్ అర్థమైందా సార్ మీకు అది?
సార్ అర్థమైంది, థ్యాంక్ యూ.
సో దట్ ఈస్ హాఫ్ బ్లడ్. Now coming to uterine blood. Uterine blood means we can the word that we can understand it clearly from the word itself. That is, uterine means uterus for a woman. So a woman who marries 2 husbands. So the children who born to that woman, that means first husband and second husband. The children born to that woman from 2 husbands, the children are related by uterine blood. Children are related by uterine blood. So now we can see Now we can see that it is mentioned wherein in clauses C and D, ancestor includes the father and ancestors means the mother. That is mentioned in, for clarification, they have mentioned in the act like that. Now we can see that F, Sapinda relationship with reference to any person. Sapinda means same pinda, mean from a common person, common ancestor. When two persons are related through a common ancestor, that is from the mother's side, it is 3 generations. From the father's side, it is 5th generation. So why I am saying this is, if a person is going to marry a woman or a woman is going to marry a person, if it is seen from his mother's side, it should be considered, it should be calculated from the ascent. That means A is a person who is going to marry B. So if he calculates the relationship with the B, that means for 5th generation, for 5 generations for his father's side, that is yes, A is the 1st generation, B his father is the 2nd generation, C is his father, I mean grandfather, and D and E. So we have to go from the bottom to the ascend, from the bottom in a ascending manner, not from the descending manner, not from the old to present. We have to go from the present to old. We have to go in a ascending manner from the present generations to the ancestors for 5 generations. That is from the father side, and from the mother side, it is for the 3 generations. If that person who is going to marry is falling under this 5 generations from the father side and 3 generations from the mother side, she will be treated as a sapinda. She will be treated as a sapinda, and they are sharing the common ancestor. So such relationships are prohibited under the Hindu Marriage Act. Next, coming to degrees of prohibited relationship. Now, degrees of prohibited relationship means a relationship which is prohibited. Why? Because a person who wants to marry A is a person who wants to marry B. So they both lineage is from the common person, like brother and sister. We can say it uncle and niece, aunt and nephew. So these kind of relationships will be treated as a degrees of prohibited relationship. So the relationship between these persons and the marriage between these persons are prohibited. Yes, Shyamala Kotiada, we have asked a question. Yeah, the consanguinity means ఏంటంటే consanguinity means by the related by blood only, right? So it will comes under the sapinda only. So blood means we have to fall back to these calculations, like in which if the person is falling under these 5 generations from the father side and 3 generations from the mother side, that has to be calculated. So in that case, definitely it will be sapinda relationship. Now coming to this, so in all these cases, sapinda relationship lo మనం తీసుకున్నట్లు sapinda relationship and degrees of prohibited relationship, the relation, that how it will be connected అంటే ఏం చెప్తారంటే, the relationship will be by full blood అయినా, by full blood, uterine blood or half blood also will be cover, that will be if a person is said to be related and by sapinda relationship అంటే, so that relationship may be half blood అయి ఉండొచ్చు, full blood అయి ఉండొచ్చు, uterine blood అయి ఉండొచ్చు, ఆర్ బై అడాప్షన్ అయి ఉండొచ్చు, ఆర్ బై legitimate అని ఉండొచ్చు, illegitimate అయినా ఉండొచ్చు. సో ఇఫ్ ద రిలేషన్షిప్స్ అంటే ఏంటంటే, రిలేషన్షిప్స్ ఫాలింగ్ అండర్ సపిండా రిలేషన్షిప్ అని చెప్తున్నప్పుడు హౌ దే ఆర్ రిలేటెడ్ అని ఎత్తుకున్నట్లయితే, వాళ్ళు ఫుల్ బ్లడ్గా రిలేట్ అయి ఉన్నా సరే సపిండాలో కలిసి సపిండా జనరేషన్స్లో పడినట్లయితే ఫిఫ్త్ జనరేషన్ 5 జనరేషన్స్ కానీ 3 జనరేషన్స్లో కానీ, సో ఈ ఫుల్ బ్లడ్లో కనెక్ట్ అయినా హాఫ్ బ్లడ్లో కనెక్ట్ అయినా అడాప్షన్ ద్వారా అయినా సరే లేకుంటే లెజిటిమేట్గా అయినా సరే ఇల్లెజిటిమేట్గా అయినా సరే దీస్ రిలేషన్షిప్స్ ఆర్ కవర్డ్ అండర్ దిస్ సపిండా అండ్ ఆల్సో డిగ్రీస్ ఆఫ్ ప్రాబబిలిటీ రిలేషన్షిప్. సో సపిండాలో నో అండి, ఇప్పుడు 5 జనరేషన్స్లో ఒక తాతకి ఒక 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 జనరేషన్ వ్యక్తికి ఒక 2 పెళ్ళిళ్ళు అయినాయి. ఒకటి అన్లాఫుల్ మ్యారేజ్, సెకండ్ మ్యారేజ్ అన్లాఫుల్ కదా. సో ద చిల్డ్రన్ బార్న్ టు దెమ్ ఆర్ ఇల్లిజిటిమేట్ కదా, అసలు సంబంధం లేదు కదా. వీ క్యాన్ మ్యారీ టు దట్ గై అండ్ దట్ ఈస్ నాట్ పాసిబుల్. వై? బికాస్ దట్ ఈస్ ఆల్సో క్లియర్లీ మెన్షన్ దట్ ఈస్ ద రీజన్ వై ఇట్ ఈస్ క్లియర్లీ మెన్షన్ దట్ even legitimate, illegitimate children who are covering under the 5 generations from the father side and also 3 generations from the mother side, they are also comes under the subpinda relationship. Even the persons who are adopted also will comes under this relationship. Coming to section 4, which is a overriding effect of this act. So this act is also, this section is also very important. So for every act there will be overriding effect of the act. Will be there, it will be provided a separate section. Why? Because it will shows to what extent this act is applicable. Extent means, I mean, to which areas this act is applicable. In some cases in some cases we can see like a specific relief act like that. In that case also there is a section which will deals with this kind of similar thing. How means, so for all the terms, for general terms, we have to refer to the contract law. The terms that are mentioned in this act, the specific relief act will be applied specifically like that. These things will be mentioned. So in this act, section 4, overriding effect of the act means whatever the acts which are present at the time of enactment of this Hindu Marriage Act, those acts will be overridden by this present Hindu Marriage Act. That is at the time of on 18th May 1955, whichever acts are pending, whichever acts are in force, or some other act, not only this act, some other acts, whichever acts are there, so those acts will be overridden by this act, giving the sanctity to all the marriages and everything. So to something, this thing. Now coming to section 5 of the Hindu Marriage Act, which is very important section of this act. Conditions for a Hindu marriage. So a marriage may be solemnized between two Hindus, specifically mentioned 2 Hindus, if the following conditions are fulfilled. First one is, neither party has a spouse living at the time of marriage. Neither party has a spouse living at the time of marriage means we can discuss it in different ways. We will discuss now. So neither party has a spouse living at the time of marriage means none of the parties, that means A and B are the bride and bridegroom. While they are getting marriage, A and B should be single, I mean unmarried till them. This is the first marriage to them, that is they are single. That is the first case, so they can marry. Second case, A is a single, B is a widow. So here B is not having husband, he was died. So in this case A and B are single, so B's spouse is not living at the time of marriage. This, and in coming to third case, A is a divorcee, B is a single person, both are getting married. Here also the prior marriage relationship is dissolved, so he is treated as a single. So that is how we should understand this specific provision. So neither party has a spouse living at the time of marriage, so both the persons should not be involved in any kind of marriage, and their marriage, if their marriages are done prior to the marriage, that should be dissolved prior to the marriage, but by the time of marriage they should be single. Now coming to subclass 2. At the time of marriage, neither party is incapable of giving a valid consent. This section we can literally say that consent. This provision subsection of 5 subsection 2 deals with the consent for the marriage. So consent for the marriage shall be obtained. The person, because both the persons are, the marriage shall be performed with the free will and willful consent only. So we cannot obtain the consent of a person by practicing fraud or by deception or something else. So it should be free, and the person who is giving the consent should be capable of understanding the terms, should be capable of understanding the situations in what they are giving the consent. That should be noted. So here they have mentioned that neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind. So if a person is if a person is suffering with unsoundness of mind, there is no possibility for him to understand what is going there, circumstances are going there. So in that case, he cannot give the free consent. So the consent should be free. Though capable of giving a valid consent, has been suffering from mental disorder of such kind, or to such an extent as to be unfit for marriage and procreation of children. So here, the person who is capable of giving a valid consent, he is suffering from certain mental disorder, and he don't know the consequences of the marriage and the procreation of children. So that should be seen, and has been subject to recurrent attacks of the insanity. So where a person is recurrently attacked with the insanity, means insanity, so he is not a fit person to give the consent. That should be seen. Now coming to subclass 3 of section 5, which is a essential condition, that is the age limit for a persons who are entering into the marriage. For a bride groom, it is 21 years. For a bride, it is 18 years. Earlier, prior to 1976, the Hindu Marriage Act, at the time of enactment of Hindu Marriage Act, this section, the age for a bride is 15 years, and it was amended to 18 years. So in the Amendment Act of 1976, it was modified and amended. Prior to that, what is the situation means, scenario means, section 6 of this act is in application. That means where a person where a bride is aged about 15 or 16 years, the consent is obtained from their parents. So that section 6 of this act was repealed by enactment by the Amendment Act of 1970, amendment in the year 1976. From then onward, the section 6 has no application. In view of that section 6 was repealed in view of enactment of Child Marriage Restraint Act. సో బాల వివాహ చట్టంని తీసుకొని వచ్చిన సందర్భం చేత ది సెక్షన్ 6ని ఏం చేశారంటే రిపీల్ చేయడం జరిగింది, రిమూవ్ చేయడం జరిగింది ఈ చట్టం నుంచి. సో నౌ ఇక్కడ ఏం జరుగుతుందంటే, సో ఫర్ ఏ bride it is 18 years age, and for bridegroom it is 21 years age. So now also there is a proposal that the marriage age for a bride should be increased from 18 to 21 years and should be treated, but that is not yet confirmed, and it is pending for approval. Consent. The bill has to be passed, and it has to take consent from the assent from the president. Now we can see section 4, subsection 4. The parties are not within the degrees of prohibited relationship unless the custom or usage governing each of them permits of marriage between the two. Here we can see, we have already discussed that the degrees of prohibited relationship. That means a person who is related, the person who is going to marry is related from the common ancestor. So here we can see in north areas or some other areas, as per the act, the aunt and nephew cannot marry, so they will come under the degrees of prohibited relationship. And uncle and niece cannot marry. They are these people, these persons, brother and sister cannot marry. So these relationships are considered as a prohibited relationships, and that was mentioned in this act. So now for this example, for this subclass, class 4, the parties are not within the degrees of prohibited relationship unless the custom and usage governing each of them permits of a marriage between the two. As per the act, that means I am saying an example for the custom and usage now. So as per the Hindu Marriage Act, the person who are having a common ancestor cannot marry. But if we see in Andhra area, in our Andhra area, we can see that ఇప్పుడు ఏం చేస్తారంటే అక్క కూతుర్ని పెళ్లి చేసుకునేటువంటి పరిస్థితులు ఉన్నాయి. అండ్ ఇన్ ద సేమ్ వే హియర్ వీ క్యాన్ సీ అక్క కూతుర్ని పెళ్లి చేసుకోవడం అంటే ద రిలేషన్షిప్ వాస్ ప్రొహిబిటెడ్ యాజ్ పర్ ది డిగ్రీస్ ఆఫ్ ప్రొహిబిటెడ్ రిలేషన్షిప్. దట్ మీన్స్ దే విల్ కమ్ అండర్ అంకుల్ అండ్ నీస్. సో మామ కోడలు వస్తుంది. సో దట్ రిలేషన్షిప్ ప్రొహిబిటెడ్ యాజ్ పర్ ది డిగ్రీస్ ఆఫ్ ప్రొహిబిటెడ్ రిలేషన్షిప్ ఆఫ్ హిందూ మ్యారేజ్ యాక్ట్. But here, this custom and usage, this practice has been done in the Andhra area since time immemorial, since long back. So this has not received any opposite from the public policy. So this custom has been practicing, and this has been considered as a reasonable in the Andhra area. This has been practicing. So the marriage between the uncle and niece, that is sister's daughter is also considered a valid marriage as per in our Andhra area. So the why I am saying this is, if we read this class 4, the parties are not within the degrees of prohibited relationship unless the custom or usage governing each of them permits of a marriage between the two. So in our area, the marriage between these two persons, as per our example, is permissible, and that has been recognized, that has been practicing since long back. So in that case, this is even the marriage performed in between the degrees of prohibited relationship is also valid. That is as per section 5. Now coming to section 5 subsection 4, class 4. Now coming to section 5, class 5. The parties are not subindas of each other unless the custom or usage governing each of them permits of the marriage between the two. That is also this example can be applied to this subsection, class 5 of subsection, class 5 of section 5 of Hindu Marriage Act. That is conditions for the marriage. In case of subindas also, this example which we have discussed can be applied. Now coming to section 6, which we have already discussed, that this section was repealed. I will just read this name of the section 6. That is, section 6 means guardianship in marriage. So as we discussed just before, that a guardian, so for a minor, the minor's consent is invalid in the eye of law. So for the consent of on behalf of the minor's consent, that is for bride who is under the age of 18 years, his parents consent was taken during that time, and the marriage has been performed. Only because enactment of this Child Marriage Restraint Act, then only this section has been repealed from the act. Until then, this act was in force, and the child marriages has been done. Now coming to section 7, ceremonies of the Hindu marriage. What are the essential ceremonies of a Hindu marriage? So as per subsection 1 of section 7, a Hindu marriage has to be performed. The marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. So if A is having some ceremonies or some customs and rites, and B is having some ceremonies and customs and rites, so the marriage can be performed or solemnized in either of the manner which they accept to. So that is subsection. Now subsection 1. Now coming to subsection 2 of section 7, wherein the essential ceremony which was mentioned. Actually, for a Hindu marriage, there are several number of ceremonies like Ganapati Puja, Nandi Devatas, Kashi Yatra, and Kanyadanam. This kind of ceremonies are there. But As per law, the only recognized important ceremony is Saptapadi. Saptapadi. That means Saptapadi means the couple who has got married walks around the sacred fire after completion of the seventh step by bride and bridegroom. The marriage has been solemnized, and that is binding on both the parties to the marriage. So Saptapadi is the important ceremony that was Saptapadi is the important ceremony that has to be performed in the Hindu marriage as per section 7. In the recent judgment, I forgot to note it down actually. The Supreme Court has held that even if the marriage is registered, if the essential ceremony, that is Saptapadi, is not performed, that marriage is treated as a void marriage, and it's an invalid marriage. So if I found that judgment, I will share with Murali sir. Sir will share you all. And now coming to this section 8. As we all know that what is the purpose of act means, the purpose of act is to codify certain rules and regulations to regulate the marriages as per this Hindu marriage act. So now to give some sanctity to the marriage and to give some proof to the marriage, so a section 8, that is registration of Hindu marriages, this provision has been incorporated, and as per this provision, for the purpose of facilitating the proof of Hindu marriages, the very opening lines of the provision, it is very clear. For the purpose of facilitating the proof of Hindu marriage, the state government may make rules providing that the parties to any such marriage may have the particulars relating to their marriage entered in such a manner and subject to such conditions as may be prescribed in the Hindu marriage register kept for the purpose. So it is empowering the state government to make certain rules and regulations and to maintain certain registers for the marriage. I mean, the persons who are who marries has to get the marriage registered. It is but it is not mandate as per the section, that we can understand by going to subsections now. Now coming to subsection 2. Notwithstanding anything contained in subsection 1, the state government may, if it is of the opinion that it is necessary or expedient so to do, provide that the entering of the particulars referred to in subsection 1 shall be compulsory in the state or in any part thereof, whether in all cases or in such cases as may be specified, and where any such direction has been issued, any person contravening any rule made in this behalf shall be punishable with a fine which may extend to 25 rupees. So even if a marriage, 1 minute please. So even if a marriage is made, even if the registration of the marriage is made compulsory as a mandate, if any person violates, that means if after marrying, if any person fails to register the marriage, even in that case also, there is a punishment of imposing a fine of 25 rupees. That is the punishment that is mentioned as per section 8 subsection 2 of this Hindu Marriage Act for contravening the provisions. So the state government shall make endeavor to prepare certain rules and regulations for the registering the marriages, so as to enable the married couple to come forward to get the marriage registered as a proof of their marriage. Now coming to this subsection 3 of section 8, all rules made under this section shall be laid before the state legislature as soon as maybe after they are made. So whenever the rules are made, immediately that should be put before the legislature for taking the consent of the legislature for making it as an enactment or certain rules. So now coming to subsection 4. The Hindu marriage register shall be reasonable, shall at all reasonable times be open for inspection and shall be admissible as evidence of the statements therein contained, and certified extracts therefrom shall on application be given by the registrar on payment to him of the prescribed fees. So whatever the registers that were maintained by the sub-registrar or the registrar of marriages, registrar of marriage, shall be kept open, shall be available open for all the time for inspection, and whatever the statements that were made in such register is admissible as per the Indian Evidence Act. That is the power that is conferred by this section on such documents, wherein we can obtain the certified copies of the documents and we can produce before the court to prove the factum of the marriage was happened. In certain cases, if the dispute comes, I mean, like if A is a husband marries B without any ceremonies, but subsequently that marriage was registered. Subsequent that if subsequently that marriage registers before a sub-registrar or register of marriage, so that forms a proof. So in future he cannot come and say that so in the absence of these persons we have married, where is the proof of marriage? And he cannot say like that if the marriage is registered. So the intention behind the enactment of this section is to provide certain proof to the marriage, so as to uh, so as to make easy to the courts to decide or adjudicate the issue when the dispute relating to the performance of marriage arises. When the marriage itself is in dispute, you can say it easily. Now coming to section 5. So now we all get a doubt that what will happen if we don't register the marriage. Is it invalidates the marriage? So even section 8 subsection 5 clearly says like that, notwithstanding anything contained in this section, the validity of any Hindu marriage shall in no way be affected by the omission to make the entry. So this section is one way empowering the state government to impose fine if they are not registered. And because we can understand section 5 subsection 5's uh, the intention behind the making of this thing. Why? Because all the people are not, we cannot expect all the people to be literate. So in some rural areas, the people will be illiterates and they don't know how to come to the sub-register office. And because of the lack of knowledge about the laws and everything, they will, after marriage, they will reside in general, and they will not go to sub-register office and get the marriage registered. In that cases, they cannot take an advantage that the marriage is not registered. So even in that case also, even if the people who forgets, who omits to make an entry in the register of marriages also, in that case, even in that case also, the marriage is valid, and mere omitting to make an entry in the register of marriages cannot invalidate the marriage, is what the intention behind the section 5 subsection section 8 subsection 5. So even if you don't register the marriage, it will not invalidate your marriage. That is section 8 subsection 5. Now coming to section 9, restitution of conjugal rights. Restitution of conjugal rights. Restitution of conjugal rights means taking back your restitution means taking back the conjugal life. Taking back your conjugal life. That means, as per section 9, if we read that section 5, section 9, so what it says means, when either the husband or the wife, without reasonable excuse, withdraws from the society of the other, the aggrieved party may apply to the court by a petition for restitution of conjugal rights, and the court, on being satisfied of the truth of the statements made in such petition, and that there is no legal ground why the application should not be granted, may decree the restitution of conjugal rights accordingly. Where a question arises whether there has been reasonable excuse of withdrawal from society, the burden of proving reasonable excuse shall be on the person who has withdrawn from the society of another. Here, the society means the marriage relationship. Here, society means marriage relationship. When either the husband or the wife, when either the husband or the wife. In here, we can see an example. We can understand this section from an example. So A is a husband. Yeah, okay. So Priyanka Virnakota, thank you. Ajay Kumar Jain and others versus State of Madhya Pradesh and others. No Hindu marriage deemed valid until Saptapadi is performed. Thank you for sending this citation. I will record it. Thank you. So now we can see we are discussing about section 9, restitution of conjugal rights. Restitution of conjugal rights. Restitution of conjugal rights. Look, first thing, and if A is a husband, B is a wife. So B files a petition stating that uh, my husband has deserted me without any intimation and he is living separately without any reasonable cause. Here, withdrawal from the society of others means, without any reasonable grounds. That means a person, A is a wife, B is a husband. A files a petition, demanding her husband to take her back to the conjugal life. So if we see, if B is a husband who is a negligent person, or who is nothing but a boozer, who is addicted to all kind of mm, bad vices. Bad vices. So in this case, no person wants to live with that person. In this case, no person wants to live that person, and he used to torture A, that is wife, every day by beating her, by using some words, by using some abusive words, etc. against the wife. So wife left the matrimonial home here. Wife A left the matrimonial home. Now B comes to the court. Saying that I am very innocent. I have not committed any kind of bad things against my wife. I never demanded. I have treated my wife very nicely, but I don't know why she left my conjugal company. Please direct my wife to join my conjugal life, like that. So here, if we see A and B, so B has meted out her wife with a torturous behavior and cruelty and humiliated her a lot. So because of the reason, she left the conjugal company of her husband. So here, the burden of proving that she has left the conjugal company of her husband shall lies upon the wife. Why? Because this provision, we can say this provision as a biased provision. Why? Because in this provision, whoever approaches the court first, the burden is very less upon him, and the court will consider the truthness and genuineness of the statements, and they are going to grant the relief. So whenever a respondent, that is the person who has withdrawn from the conjugal life of another person, the burden is upon the person who left the conjugal company. They have to prove. That means these are the circumstances which made me to go out of the conjugal life of my husband or my wife, so that because of that only I am unable to bear the cruelty and the harassment from my husband, that made me to go out of the relationship. That is the reasonableness that has to show by the person who left the conjugal company. So ultimately, if the court feels truthness, that is truthness of the allegations, basing upon the proof, the court finds who is correct and who is wrong, then the court will accept the petition and grants the restitution of conjugal rights against the respondent. If the petitioner fails to prove, in this case, if the respondent proves that she or he has left the company by showing the reasonable grounds, then the burden shifts upon the petitioner here. So he has to prove no, she left for the reasons mentioned in the petition, being a negligent person, being a so and so person, she left the so and so. Then we have to prove. Even then also even then also I'm having respect over the marriage institution, and I want my wife or I want my husband back into my life, so to look after me and my children, so on so like. So the burden shifts. So if the respondent proves that she or he has left the conjugal company by showing the reasonable grounds, then they will get. So the burden shifts on to the petitioner. So upon deciding the evidences, discussing on evidences and the law and appreciation of acts in the criminal, the court will grant. So after granting of the restitution of conjugal rights decree, the person has to join the marital life. I mean, has to join the conjugal life within 1 year. So this thing, this limitation of 1 year has not discussed in this section, but it was discussed. We have to take a recourse from section 13 in divorce. I mean, section 13 grounds for divorce. Why? Because if a person fails to join the matrimonial life, that is conjugal life of the petitioner within 1 year from the court decree, so it will amount to the contempt, and it can be a ground for taking a divorce. So even if you want if you want the decree to be executed against them, then we have to take the recourse of civil law. I mean, code of civil procedure, execution of decrees relating to the matrimony. That will be discussed in Order 21, Rule 32 or 33, I think. Okay. So there it will be discussed. So now coming to Section 10, judicial separation. Judicial separation. So here I would like to make a note with regard to this section 10 is we have to, the people who are preparing for this judicial exams, they have to note this. Either party to the marriage, section 10 subsection 1, either party to the marriage, whether solemnized before or after the commencement of this act, may present a petition praying for a decree of judicial separation on any of the grounds specified in subsection 1 of section 13, and in case of a wife also any of the grounds specified in subsection 2 thereof, as grounds on which the petition for divorce might have been presented. So here we can see section 10 of judicial separation, section 10, which is judicial separation, whether solemnized before or after the commencement of this act. So the marriage is solemnized even before the commencement of the act, that is on 18/5/1955. If the marriage is solemnized even prior to this date or after this date, this act is made commonly applicable retrospectively and also prospectively. So here here if you can see that so judicial separation on any of the grounds. So what are the grounds that are discussed? So on what grounds you can ask for the relief of judicial separation? That was the grounds that are similar to the grounds mentioned in the divorce, grounds for divorce. So the general grounds will be the having an extramarital affair, and next one is cruelty, desertion, renouncing the world, conversion, suffering with venereal diseases, leprosy, incurable form of leprosy. So these kind and some more are there that we will discuss in coming sections. So on these grounds, he or she can present a petition to the court for judicial separation. Separation in the sense means the court will grant the order of separate living, that is a spouse, uh, for two spouses for an year. So if these persons will cohabit in this time after the decree of judicial separation, then the decree becomes null and void. So ultimately the person who says that the decree of the judicial separation has become null and void, is the burden lies upon him to prove the same, that the separation was not there, it was it was disturbed, and the separation was disturbed, and it has to be proved before the court who is contending the same, that is the judicial separation has been disturbed or something. So judicial separation will be given on the grounds that was set forth in the section 13 of the Hindu Marriage Act. Now coming to judicial separation 10 subsection 2, where a decree of judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit with the respondent, but the court may, on the application by the petition of either party and on being satisfied of the truth of the statements made in the petition, rescind the decree if it considers it just and reasonable to do so. So, as we discussed, so when a decree of judicial separation has been passed, there will be no obligation on either of the spouse to cohabit, to live together, or to cohabit or live together. So if any of the party, if the both parties feels that the marriage is the disputes and something else that was that which are the grounds under section 13 have been settled, like if a husband files judicial separation against his wife, saying that pleading cruelty. After passing judicial separation, the things were sorted out by them, and they started cohabit, living under one roof. But that means without separation, they are living under one roof, and they can make an application then to rescind the decree of judicial separation. So by jointly or the petitioner who has got the decree, they can file a petition for judicial separation, the lifting of the, recall or rescinding the order of the judicial separation. So in this case, so if the both parties feels good to continue their marital relationship, then they can proceed for judicial separation. Feels the proceed for the further, they can rescind the order of judicial separation by making necessary application. If the order is complied strictly, that means there is no cohabitation between the both spouses for more than 1 year, then it becomes a ground for divorce. This was said in the section 13 that we will discuss. Now coming to nullity of marriage and divorce. This is discussed in chapter 4 of the Hindu Marriage Act 1955. That is, chapter 4 deals with the nullity and divorce, nullity of marriage and divorce, nullity and marriage and divorce. So section 11, void marriages. That the term void marriage itself, we are clear that it is clear that the marriage is a invalid and it is not having any sanctity under the law. How? What makes the marriage invalid or void? That we will discuss, we will see now. Any marriage solemnized after the commencement of this act shall be null and void, and may, on a petition presented by the either party thereto against the other party, be so declared by the decree of nullity if it contravenes any one of the conditions specified in the clause 1, clause 4, clause 5 of section 5. As we all discussed in the section 5, the conditions of a Hindu valid marriage. So what is section 1 deals with? Section 1 deals with the either of the spouse leaving, sorry, I'll go to this. So both the parties to the marriage shall be single. So either of the spouse has a spouse leaving at the time of marriage. So no spouse to the marriage shall be having a spouse at the time of marriage. So as we discussed that, so A and B are getting married. So both shall be single, or both shall be single. Like in many ways, like divorced, both are divorced. So there should not be any kind of previous relationship. So if A and B marries, suppose if A is already married to someone, so prior to this marriage, if he marries B, then what will happen means A marriage with the B is invalid. Why? Because there is a marriage already existing. There is a marriage already existing, and that marriage was not dissolved, is not dissolved by a decree of divorce. So in that case, the marriage between A and B is void marriage. Why? Because it is contravening the provision, that is essential condition of section 5 subsection 1. So that is void marriage. That becomes void marriage. Now coming to 4 and 5, subsections 4 and subclass 4 and 5 of section 5, that deals with the Kapinda marriages and degrees of prohibited relationships. Hmm. So, so in our case, we have already discussed about the Andhra area relationships like that. So if a marriage is recognized, if the custom and usage is recognized, if the degree of prohibited relationship, custom and usage has been recognized for a long time, that has to be proved by the parties who are doing the same. So that marriage, that means that the marriage that was happened in Andhra areas, which was accepted by the public and which has been practicing since long back, that does not falls under the void marriages, as we discussed in our discussion earlier. So this act makes that, so the marriages which within the degrees of prohibited relationship, within the Sapindas relationship, or void marriages. Adding to that, and the persons who have already married and marrying to some other person is also invalid in the eye of law, in view of section 11, that it will becomes in void marriage. So coming to the voidable marriage. So voidable means it may become invalid or become a valid. That will be at the option of the parties. So voidable marriages. So if we read section 2, all these voidable marriages, any marriage solemnized, whether before and after. So this has to be read clearly. Okay. So if you read section 11, that section will discuss us after the enactment of the act, after the commencement of the act, whatever the marriages that were happened, that was solemnized after the commencement of the Hindu Marriage Act, only it has application. For all the marriages which was performed prior to the 1955, that is enactment date, for those acts, for those marriages, section 11 has no application. So we have to remember this thing. Why? Because section 11 has only prospective effect but has no retrospective effect. Now coming to section 12, voidable marriages. It has prospective and retrospective effect. Any marriage solemnized whether before or after the commencement of this act shall be voidable and may be annulled by a decree of nullity on any of the following grounds, namely, the marriage has not been consummated owing to the impotency of the respondent. Second one is that the marriage is in contravention of the conditions specified in the class 2 of section 5. So here, if the respondent is impotent and who is not fit for consummation, that marriage, why? Because the very purpose of the marriage is to create the lineage and offsprings of the persons. In other sense, we can say it as a for one person, for one man, one woman. Then for all the things, that has to be between the two persons only, not from the third person. And so impotency, the potency is one of the essential thing to create the offsprings. That means to create the next generation of them and to continue their lineage. So that is also one of the purpose of the marriage as per the Hindu mythology. Now we can see here that the impotency of the respondent is one of the ground for making the marriage voidable. Why means voidable? As we discussed in the beginning of the section itself, voidable means we can make it void or we can accept it. So in this case, for some couples, having children is an option. For some persons, it becomes mandate. I mean, they wants to have children. They wants to procure. I mean, they want to create their offsprings. So here, if the person, if any of the person in the if any of the spouse feels that that is okay, that is not an issue for the marriage, for leaving two couples, for having a good life between two persons, so that is a viable marriage. So viable marriage, they can have it, they can accept it, and they can continue in their relationship. So to the persons who wants to continue their lineage, like that, we can see this kind of marriages in our olden days, like a male person who definitely wants a potent wife. That means who can able to produce children. So in those cases, we have seen a lot of persons who has a lot of men who has mm, who has practiced a lot of cruelty against the women in olden days for not giving birth to child. So in that cases, so if a woman is impotent, she can they can take a divorce, they can get the marriage voidable. I mean, they can get the marriage void, and by a decree of void from the court. So this, but presently this it has been increased in present cases also. The thing is, there is a change. There is a change in this practice. Like the women are filing cases against the men because of the importance. So now coming to subsection 1, class B. We have discussed class A, now we are seeing class B. So the marriage is in contravention of the conditions specified in the class 2 of section 5. What is class 2? I mean, class 2 of section 5 deals with means we can literally discuss about the consent from a unsoundness person. So if these facts are suppressed, if these facts are suppressed, and if the
చేసుకోండి ఎవరు ఇది అనిల్ కుమార్ గారు ఓకే ఓకే
sir, okay, sir. So if the marriage was performed in contravention to this consent clause in section 5, then we can make the marriage as voidable. Why? Because that is the option of the parties to make it void, or they can accept to continue in the relationship. For some persons, it is okay. I mean, in case of a unsoundness in case of a unsoundness person, I mean, insanity. If a person is suffering with insanity, who is getting attacked with some kind of recurrent attacks of insanity during some specific periods, for that persons, that is understanding between the couple. If they want to continue, let it be okay. That will be for a few months. That is okay, fine. So that is between the couples, that as per their understanding, so they can make it as a void or voidable. So the consent that was obtained by during that course can be make it void, and we can make a we can put an end to the relationship by invoking this subsection 1B of section 12. Here we can see class C of subsection 1. So that the consent of the petitioner, or where the consent of the guardian in marriage of the petitioner was required under section 5, as it stood immediately before the commencement of the Child Marriage Resistant Act, the consent of such guardian was obtained by force or fraud or nature of ceremony. So here, as we discussed about section 6, so if the consent of a person to the marriage, or consent of persons, in a sense, we have to read in the by clubbing with this guardian. So for a bride who is under the age of 18 years, as we discussed, the consent should be given by the parents, that is guardian, as discussed. So guardian, when the consent of the guardian is obtained by practicing the deception, by practicing fraud, by something else. So if the consent is obtained by fraud or something, coercion, or by practicing some kind of influence, then such consent is a invalid consent, and we can go to the court and ask the court to grant a decree for making the marriage void, on the ground that the consent is obtained by force or coercion or something. That was discussed in this thing. That the respondent, and now coming to class D, that the respondent was at the time of marriage pregnant by some person other than the petitioner. So if it is specifically mentioned pregnant by some person other than the petitioner. So here this provision is specifically for a man who came to know that his wife was already pregnant, not through by him. So in that case, he can file a petition to make the marriage void. If he wants to put a break, if he want to break the marriage tie, he can file a petition to make the marriage void. No, otherwise, if he is okay, if he is accept, if he knows it, and if he continues to be to continue with that lady after getting knowledge about the same, then it will be, we can take it as implied from circumstance that he has accepted the marriage, and he can make it voidable. That means he can accept the marriage without proceeding to make the marriage void. So here there's a limitation in this section. Means whenever he has discovered the fact that she is a pregnant, not by him, then he has to make the petition within 1 year from the date of knowledge of such recognition, which from knowledge of such discovery that the woman is pregnant. So within 1 year, he has to file a petition before the court. He has to file a petition before the court to asking for the decree of nullity or nullity of the marriage, decree of nullity of the marriage. Now coming to subsection 2 of section 2. Notwithstanding anything contained in subsection 1, no petition for annulling of a marriage on the ground specified in class C of subsection 1 shall be entertained if the petition is presented more than 1 year after the force had ceased to operate, or as the case may be, the fraud has been discovered, or the petitioner has, with his or her full consent, lived with the other party to the marriage as husband or wife after the force has ceased to operate, or as the case may be, fraud has been discovered. So in this case, as we discussed in this section C, subsection C of section 1, if the consent is obtained by practicing fraud or some coercion or some force or something else, if the party wants to put an end to the marriage, he or she has to make an application within 1 year from the date of such discovery that the fraud has been practiced, or the fraud has been ceased to operate. So if any person continues having the knowledge for years together, like after knowing fully well that after knowing that the consent was obtained by fraud, if a person, he or she may live for years together, like 3 or 4 years or 5 or 6 years, and they procreate children. They procreate children knowing fully well that the consent was obtained by fraud. In that case, he or she cannot come and ask the court that my consent was obtained long back. So I know that I know it very recently. I know it so and so date. So please entertain my petition. That is not entertained. Why? Because there is a specific limitation of 1 year from the date when you have discovered that your consent is obtained by misrepresentation, by false statements or something else. You have to ask for this relief. If you want to exercise this relief, definitely you have to make application within 1 year from such discovery. Now coming to subsection 2 class B, on the ground specified in class D of subsection 1 shall be entertained unless the court is satisfied that the petitioner was at the time of marriage ignorant of the facts alleged. So if he is ignorant of the fact that she is pregnant, so then the petition is entertained. Entertained. That too has to give the statements to the satisfaction of the court. Next, the proceedings have been instituted in the case of a marriage solemnized before the commencement of this act within 1 year of such commencement, and in case of marriage solemnized after such commencement within 1 year from the date of marriage. So if the section, if this kind of as discussed in subsection 1D, if the pregnancy is discovered prior to 1 year, so this application is given, that is retrospectively 1 year prior to the marriage, prior to the enactment, and discovery is made within 1 year prior to the enactment, and within 1 year prior to the enactment. So that was given in this case. Proceedings have been instituted. Okay, next, that the marital intercourse with the consent of the petitioner has not taken place since the discovery by the petitioner that the existence of the said ground. So after discovering the fact that she is pregnant not by him, not through him, so there is no cohabitation between them, there is no marital intercourse between them for more than many periods. So that will be a ground for them to ask, that will be a ground for them to file application under this act, under this section. So wait a minute, sir, please. Now coming to the section 13, grounds of divorce. Divorce. So here there are certain grounds wherein you can ask for the divorce, wherein the aggrieved party can ask for the divorce. Any marriage, whether solemnized whether before or after. See the wordings of this section. This section is also have application retrospectively and also prospectively, whether before or after the commencement of this act may, on a petition presented either by the husband or the wife, be dissolved by a decree of divorce on the ground that the other party, now the grounds are mentioned. That, so first subclass, subsection 1, clause 1, wherein it is mentioned that has after the solemnization of marriage, had voluntarily sexual intercourse with any other person other than his or her spouse. So if a person who is having a extramarital life, that is who had sexual intercourse other than with the spouse, so that will be a ground. So whenever a person alleging this ground, the burden of proof heavily lies upon the person who is alleging that my spouse, that is the other party, is in extramarital relationship with someone else, and who had also had an extramarital intercourse with the other person. So in this case, they have to prove it strictly with all the proofs. So that is one of the ground. So having extramarital sexual relationship with other person is a ground, other than the spouse, is a ground for the divorce. Now coming to subsection clause 1A. He has after the solemnization of the marriage treated the petition with the cruelty. Here it was mentioned that cruelty. So the cruelty may be by words, that is mental cruelty and physical cruelty. For physical cruelty, there will be certain some sort of evidences like the scars on the body. The person is treated with some cruelty, like we can prove it. The physical cruelty, we can prove it. But for the mental cruelty, it is very difficult to prove. It has to be established by the circumstantial evidence and by producing the oral evidence. But the best witnesses to this cruelty is that husband or the wife. So here, in this case, the cruelty is not defined anywhere under any act. So it depends upon the person to person. It depends upon the case to case. So for example, if a person, if a person A is a wife, B is a husband. So A is a woman who has been brought up in a very high profile family, and she has lived her life in a very lavish manner. So she marries to a person who is a salaried, monthly salary guy. Meanwhile, while the marriage life is going on, they have some disturbances between the there are some differences between disturbances because of the lifestyles. So for a person who has who has brought up in a high profile family, uh, the respondent is unable to provide that kind of status, that kind of family lifestyle to that woman. And apart from that, treating her with negligently or doing something else against her will give some kind of cruel to the person who has brought up in a high profile family, wherein because there will be no day for her to sleep with hunger, and this kind of things will be there. So depends upon case to case and facts to facts, the cruelty is defined. Even Supreme Court and different high courts of our different high courts of our India, nowhere it is discussed that, nowhere it is defined that this is the cruelty and this has to be followed. There is no measurement for cruelty. The cruelty is defined, and they has to be independent as to different each case. It is independent to the each case. So now we are going to the desertion. Desertion, that is class 1B. So here has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of this petition. So here we can see, so where a person deserting the another petitioner. So if A is a husband and B is a wife, sorry, the wife deserts husband, leaving the conjugal life, leaving the matrimonial life without any plausible ground, that is reasonable ground. She left the husband and she lives separately for more than 2 years. For more than 2 years. So for more than 2 years, there is no cohabitation, there is no consummation of marriage, there is no intercourse between the two couples. So that will becomes a ground. Leaving apart for more than 2 years is a ground which can be bring into the desertion. So to file a petition under this act, there shall be the mandate time period is 2 years shall be separation. That is a thing which we have to be noted, keep in mind before making an application. Now coming to subclass 2, class 2, who has converted into another religion. If a person who has converted into another religion, for example, A and B are Hindus by the time of marriage. B is the husband who converts into Christianity without intimation or without information to anybody else. Now he becomes a Christian. So now the marriage automatically, now this case, conversion into another religion becomes one of the best ground to get the divorce from the court. Get the divorce from the court. Next, coming to a person has incurably of unsound mind or has been suffering continuously and intermittently from mental disorder or of such kind, and to such an extent the petitioner cannot reasonably be expected to live with the petitioner. So here, if a person is suffering with incurable mental disorder or incurable unsoundness of mind, or incurable, that means which is unable to cure. So in these cases, it will definitely cause us hardship to another person. So considering this and taking this ground, this is unsoundness of mind as a ground, we can file a petition for divorce. Now coming to person has been suffering from a virulent and incurable form of leprosy. So leprosy, which is incurable form, is also a ground for filing a divorce petition. Now, and another one is venereal diseases in a communicable form. Venereal diseases means the diseases which will spread when two persons came into a physical contact. So when these disease, when a person, either of the person is suffer, either of these spouses is suffering with the venerable diseases, which is in a communicable form. That means spreading in a spreading form. So that contaminating and spreading form. So that is also a ground, which is a incurable disease. That has to be noted. So the disease shall be incurable disease, venereal disease in a communicable form is also a ground for seeking divorce. Has renounced the world by entering any religious order. So here, so సన్యాసం పుచ్చుకోవడం అంటారు. Renouncing the world means సన్యాసం పుచ్చుకోవడం. So ఒక వ్యక్తి either A or B, a wife or husband, renounces the world by accepting the by renouncing the world by accepting some of the religious orders. So if any of the person becomes sannyasi, so the other spouse, that becomes a ground for other spouse to file the divorce petition. Next one. If a person has not been heard for a period of 7 years or more by those persons who would naturally have heard of it had that party been alive. So here this is a provision which is related to Indian Evidence Act also, that is section 107, 108. So wherein it was, it was discussed that if a person is not heard for more than 7 years, it is a presumption under the law that it is presumed that the person is dead, presumed to be dead. So this has been taken and it has been incorporated here. If A and B, if B is a person who went for some traveling to the world trip like that, so he went there, he went like that, but he has not returned for more than 7 years, and his presence and his whereabouts were also not known to any of the persons. So in that case, that that also a ground for taking divorce from the court of law. Now there is an explanation that is mentioned in section 13. In this subsection, the expression desertion means the desertion of the petitioner by the other party to the marriage without reasonable cause and without the consent or against the wish of such party, and includes the willful neglect of the petitioner by the other party to the marriage, and its grammatical variations and cognate expression shall be construed accordingly. So the explanation, they have mentioned what should be a desertion, what shall be a desertion like that. So wherein, so without any reasonable cause and without the consent of the opposite party and against the wishes of the other partner of the marriage, some person willfully neglecting them and leaving separately from the one partner of the marriage, one spouse. So that has to be considered as a desertion. Now coming to subsection 1A, either party to the marriage, whether solemnized before or after the commencement of this act, may also present a petition for dissolution of the marriage by a decree of divorce on the ground that there has been no resumption of cohabitation as between the parties for the period of 1 year or upwards, whether the passing of decree for a judicial separation in the proceedings to which they were parties. So as we discussed in section 10, so judicial separation, if there is no cohabitation between the parties for 1 year or more, then it will becomes a ground for the judicial separation. It will becomes a ground for the divorce. Now coming to subsection 1A clause 2. So that there has been no restitution of conjugal rights as between the parties to the marriage for a period of 1 year or upwards after passing of the decree for restitution of conjugal rights in a proceeding to which they were parties. So as we discussed in section 9, so even after passing a decree of restitution of conjugal rights, if either of the party against whom the order is passed fails to comply the order of the court to join the conjugal company of the another partner, definitely that amounts to a ground for the seeking the divorce to the party who has got the conjugal restitution of conjugal rights order. Now this section 13 subsection 2 is specifically for a wife. These grounds are only for the wife who is intended to file the dissolution of marriage, that is divorce. So in the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that any other wife of the husband married before such commencement of act was alive at the time of solemnization of the act. So this section, this specific clause is similar to the essential conditions of the marriage, section 5, subsection 1. So this section also says that if a, for example, as we discussed, prior to 1955, there is a polygamy, that is a male marrying 2 or 3 wives, more than one wife. So in that case, if a woman marries, if a woman marries that person who is having a spouse, after this enactment, she can seek for divorce. Prior to this amendment, since there is no provision, for the woman to take divorce, so there were many women who was lived like that and spend their life. But the woman who wants to come out of the relationship, like who doesn't want to be a second wife, who doesn't want to be a third wife, she can file a petition under this section 13 subsection 2. So saying that he is already having a woman in his life and he married to me as a second wife, so I want to come out of the marriage. That is the ground for this. That will be the ground exclusively for the woman to come to file for the dissolution of the marriage. Now coming to the subsection 2 of subsection 2, class 2 of subsection section 2, that the husband has, since the solemnization of the marriage, has been guilty of rape, sodomy, and bestiality. So if the husband is guilty of offense under section 375, 376 of Indian Penal Code, and bestiality and sodomy, which are the unnatural sexual offenses. So if he is guilty of these kind of offenses, it becomes a ground for the wife to seek the divorce. Now coming to section class 3 of subsection 2 of section 13, that in a suit under section 18 of Hindu Adoptions and Maintenance Act, or in a proceedings under section 125 of Code of Criminal Procedure, or in a proceedings under section 125 Code of Criminal Procedure, a decree or order, as the case may be, has been passed against the husband, awarding the maintenance to the wife, notwithstanding that she was living apart, and that since the passing of such a decree or order, cohabitation between the parties has not been taken place. So here, if an order is passed, that is section 18 deals with the maintenance of wife. Section 18 of Hindu Adoptions of Maintenance Act deals with the maintenance of the wife. If the wife gets an order under section 18 or section 125 of CRPC, if the husband fails to comply the order and they live separately for more than 1 year, without compliance or without compliance of the order, they are living separately, then that also becomes a ground for the wife to file the divorce petition before the court of law. Next, that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years, and she has repudiated the marriage after attaining the age, but before attaining the age of 18 years. So here, this specific provision is relating to section 6, during the situations of the child marriages where it were happening. So in that period, if the bride is of 15 years or less than 15 years of age, if she came to know that marriage is that the marriage was performed against her will and wishes, so during that time only she has reputed. That means she has not accepted the marriage, knowing that marriage was the child marriage, or that was against her wishes. Then she can file the petition under this act after attaining the majority. She has reputed the marriage after attaining that age, but before attaining the age of 18 years. So this, as per this section, she can file the petition before 18 years itself. So that is clear from the wordings. That means that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years. And she has repudiated the marriage after attaining that age, but before attaining the age of 18 years. So before attaining the age of 18 years, she has to make an application before the court to uh, take the divorce from the court of law against the marriage. So that is section 13, the grounds of section 13. So there are common grounds for husband and wife, and there are certain specific grounds that are mentioned in subsection 2 of section 13. Section 13. Now coming to section 13, 1A. Wait a minute.
సార్ అభిలాష్ గారు కంటిన్యూ చేస్తాం లేదా నెక్స్ట్ రేపు తీసుకుంటారా?
సార్ 15 వరకు చెప్తాను సార్, 15 తర్వాత చేద్దాం సార్.
సరే మళ్ళీ
Section
కంటిన్యూ
15
రేపు ఈవినింగ్ కావాలా?
సెక్షన్ 15 వరకు చెప్పేస్తాను. ఒక
ఆ.
1 minute వేరే కాల్ వచ్చింది వాళ్ళు, ఒక్క నిమిషం.
ఓకే అలాగే.
Now we will discuss about section 13A, alternative relief in divorce proceedings. Alternative relief in divorce proceedings is sumoto powers that is granted to the court, or you can make an application. Or the court can grant sumoto orders under section 13A. That is alternative relief in divorce proceedings. In any proceedings under this act, on a petition for dissolution of marriage by a decree of divorce, except in so far as the petition is founded on the grounds mentioned in clause 2. I mean subclass 2. That is that we can say that is conversion into another religion, and clause 6, that is renouncing the world, and clause 7, that is not heard for 7 years. Of subsection 1 of section 13, the court may, if it considers it just so to do, having regard to the circumstances of this case, pass instead a decree for judicial separation. So if the court feels that the judicial separation will help the spouses, will help this marriage institution, and to continue further, the court can order the judicial separation, except in the cases where that is when the spouses have renounced the world, when either of the spouse has converted into another religion, and when this when either of the spouse is not heard for 7 years. So except in those cases, the court can order for judicial separation for 1 year summatively or by an application by the parties. Now, coming to that is the alternate relief in divorce proceedings. So the court feels that there is a possibility of reunion or something else. So if the spouses to the marriage, they can live together and they can live. So then if the court feels fit, then it will order the alternate relief of judicial separation in the divorce proceedings. Now coming to this section 13B, which is a trending divorce in the current Indian current Indian society. That is divorce by mutual consent. Divorce by mutual consent. Subject to these provisions, that means the only that thing which we have to remember in this subsection section 13B is so a divorce by mutual consent. That means both the spouses to the marriages files an application by arriving at understanding that they are going to dissolve the marriage. So there will be no any kind of undue influence or duress or something, coercion or something on them. So they come to the court filing the application that there is no possibility of reunion of the marriage and there is no possibility of living together. So then in those circumstances, both the petitioners, that is husband and wife, or the petitioners in this case, there will be no question of respondent in this case. Both the parties come to the court, files the petition seeking the divorce by mutual consent. So mutual consent, in this mutual consent, the essential condition is both the spouses shall be living separately for more than 1 year from the date of from the date of issues. That means the essential condition, the precondition for filing this petition is 1 year separation is mandatory. And second thing is in this case, when subsection 2 that was discussed in subsection 2 of 13B, it was discussed that so after application of the parties, there will be a period of 6 months period that is called cooling off period. Cooling off period will be there in this case after filing the divorce by mutual consent application before the court of law. Why the cooling period is? The cooling period is the chances that are given to the spouses. If there is any possibility of reunion, then that will be cooled off. So at the time of filing the petitions, at the time of disputes between the parties will be under the heated situation, so that there will be no chance of reunion. So because of this cooling period, there is a possibility of reunion, and the parties may come down and they may think of the relationship, and if they want to continue, they can proceed with the relationship. So that is the purpose of giving this cooling period. So after this 6 months, a day, I mean, after filing the petition or presenting the petition to the court, 6 months time will be given. That is a cooling period. From that is the 6th month date, a date is given. From that date to 18 months, within 18 months, the petition has to be disposed of. So that is the time limit that was mentioned in this section 13B with regard to the divorce by mutual consent. Even in many of the cases also, this 6 months cooling period has been waived off by the courts. It is only an option that is mentioned but that can be waived off by the parties by presenting a petition to the court seeking that there is no possibility and there is no chance of reunion. There is no possibility and there is no chance of reunion. That is the situation. And even recently, the Andhra High Court also said that the 6 months cooling period is a mandatory but not directory. So that period can be waived off if there is no possibility that the marriage is going to reconcile or reunion. The marriage between the parties is going to reunion. Now, section 14. No petition for divorce to be presented within 1 year of the marriage. So this section clearly says that there shall be no petition for divorce within the 1 year of marriage, except under the exception circumstances. So if you want to make an application for the divorce within 1 year of marriage, first you have to file an application under section 14 of this act along with the divorce petition. Means if we read the provision of this section 14, notwithstanding anything contained in this act, it shall not be competent for any court to entertain any petition for dissolution of marriage by a decree of divorce unless at the date of presentation of the petition 1 year has elapsed since the date of marriage, provided that the court may, upon application made to it in accordance with such rules as may be made by the High Court in that behalf, allow a petition to be presented before 1 year has elapsed since the date of marriage on the ground that the case is one of the exceptional hardship to the marriage to the petitioner or of the exceptional depravity on the part of respondent. But if it appears to the court at the hearing of the petition, the petitioner obtained leave to present the petition by any misrepresentation or concealment of the nature of the case, the court may, if it pronounces a decree, do so subject to the condition that the decree shall not have effect until after the expiry of 1 year from the date of the marriage, or may dismiss the petition without prejudice to the petition which may be brought after the expiration of the said 1 year upon the substantially the same facts as those alleged in the support of the petition, so dismissed. In disposing of any application under this section for leave to present a petition for divorce before the expiration of 1 year from the date of marriage, the court shall have regard to the interest of children of the marriage and to the question whether there is a reasonable probability of reconciliation between the parties before the expiration of said 1 year. So, if any party intends to dissolve the marriage before 1 year, at first they have to take the leave of the court before making an application. After getting the permission from the court, then the petition will be admitted. So even in that case also, if any decree is passed, if any decree of dissolution of marriage is passed within 1 year, so that decree will be having effect after the lapse of 1 year from the date of marriage, but not within the 1 year of the date of marriage. That is the
అంటే అదేదో ఉంటుంది కదా పైన ఇలాగా అది తప్పుకుంది కదా ఆ.
So,
ఓకే
so even sir, ఈ పాయింట్ డిస్కషన్ సార్ ఇది
సార్ చెప్పండి.
ఏదో క్వశ్చన్ అడిగారు కదా ఇప్పుడు క్వశ్చన్ అది ఏమన్నా
ఏం లేవు.
ఓకే ఓకే సార్. సో నౌ కమింగ్ దీంట్లో సెక్షన్ 14 subsection 2 is the thing when the court has decided the petition, so the children rights has to be also decided by the court if the petition is entertained within 1 year. So that is the section 14 of the Hindu Marriage Act. Now coming to section 15, divorced persons when marry again. So ఎప్పుడు డివోర్స్ అయిన వ్యక్తులు మళ్ళీ పెళ్లి చేసుకోవచ్చు, రీమ్యారేజ్. సో when a marriage has been dissolved by a decree of divorce and either there is no right of appeal against the decree, or if there is such a right of appeal, the time for appealing has expired without an appeal leaving having been presented, or an appeal has been presented but has been dismissed, it shall be lawful for either party to marry again. So when the decree is specific, when the decree of divorce is specific that there is no right of appeal, then the party can marry again. When the limitation the limitation for filing an appeal is 30 days. So 30 days mean 30 days and it differs also. So in that case, after expiration of appeal time, after expiration of appeal time, the parties can remarry again. So in another case, if an appeal is preferred but the appeal is dismissed on contest, even in that case also the party is entitled to marry again. So that is as per section 15 of the Hindu Marriage Act. So as up to this, we have discussed the provisions relating to the divorce, rights that are provided under the Hindu Marriage Act and its procedure, how to get a divorce from the court if opposite spouse is practicing any cruelty, desertion or something, if they are not okay with to continue in the relationship. So this can be treated as a part 1 class. because it has already consumed 2 hours of time. Sorry for that. And sir, mala next episode పెట్టుకుందాం సార్, సెకండ్ పార్ట్.
సార్ మీ టైం చెప్పండి, మీ టైం.
టుమారో మీకు ఓకే అంటే మనం పెట్టుకుందాం సార్, ఒక 6 to 7.
ఓకే, టుమారో టైమింగ్
6 to 7.
టుమారో 6 o'clock కంటిన్యూ చేస్తాం. ఓకే,
6 to 7. So this is the major part which we have discussed now, and the remaining rest of the part will be very small. తక్కువ ఉండొచ్చు, త్వరగా అయిపోతుంది. 1 hour is sufficient for that. If anybody is having
tomorrow
doubts,
6 o'clock
you can ask. Sure sir. If anybody is having doubts, you can ask.
సార్ ఇప్పుడు హలో
చెప్పండి
సార్, ఇప్పుడు మ్యూచువల్ కన్సర్న్స్ లో డైవర్స్ తీసుకున్నప్పుడు మనకి 6 months తీసేసారా సార్? అంటే ఆన్ ది స్పాట్ ఇచ్చేస్తున్నారా కొత్త అమెండ్మెంట్ లో ఏమైనా?
No sir. అదేంటంటే the thing that is happening is that is mentioned in the act. 6 months period is not removed from the act. Whenever it is expressly removed from the act, then there is no 6 months period anadi. So that is waiving off by the High Court and Supreme Courts anamata. So Priyanka Vinnakota garu pettunaru, the Telangana High Court waiving of the cooling period in the Dandamudi Pani Krishna versus Boyapati Lakshmi. So the 6 months cooling off period anedi that can be waived off. That is not a directory that which has to be strictly followed by the courts, but it is a mandatory thing. So if it is followed under circumstances where there is a possibility of reunion, if there is no possibility of reunion, then the parties can file a waive off cooling period, 6 months waive off cheyamani petition eskunesi, they can take divorce andi.
Okay. I heard somewhere, so I asked you.
No, and it was not removed from the act. So it is expressly mentioned in the act that period is not removed.
Cases matrimonial cases ani remove chesarani vinnanu. Is it correct or wrong? Just verify.
No sir. That is mentioned in the act itself. That is act lo undi, cooling period can be waived off by presenting an application.
Thank you, sir.
Any other doubts?
ఓకే, థ్యాంక్ యూ సార్. రేపు మళ్ళీ 6 o'clock అట్లా కలుద్దాము.
Yeah sir, sure sir. Please share me the link sir, join అవుతాం తప్పకుండా. Okay sir, thank you sir.
ఓకే, థ్యాంక్ యూ అభిలాష్ గారు.
Thank you sir.